Jacte, I now call Deputy Tommy Broughan.
Thanks, Laskin Corla. So I'm glad to have the opportunity to say a few words on this very important piece of legislation, which outlines, I suppose, some fundamental reforms of industrial relations and employment law. I do have concerns, Minister, about the resources currently allocated to NERA, to the, if you like, inspection enforcement area of this whole sector. You told me, I think, a few months ago that there are something like 100 inspectors only available, effectively, I suppose, to police a workforce of approaching 2 million citizens. So there is a concern, I think, that this I suppose, merited attempt to streamline and standardise the system of dispute resolution, that it could, it could be motivated maybe more by cost-saving grounds than by actually getting, a better industrial relations machinery. But undoubtedly, the bill does include wide-scale and major reform, Laskin Corla, of the employment rights disputes resolution. I hope that the reform will lead to improvements in upholding workers' rights and their access to justice, and we've had so many astonishing cases where workers have been treated very badly in this country, raised in this House, as I've done myself, in fact, in recent months, and absolute necessity to address those injustices urgently. I welcome, obviously, the creation of the specific section of your department now, which will with responsibility for collective bargaining and small business. I'd also hope there is a similar commitment on the part of the government, probably now in its final year of office, at the longest, Minister, to bring forward the legislation on collective bargaining, because obviously you might remember, I think it's nearly 16 years since I myself brought forward the Trade Union Recognition Bill into this House on behalf of the Irish Congress of Trade Union and the SIPTU Trade Union in particular. And 16 years later, this area is still a very important sector of the life of the Irish people that this House hasn't addressed. So I would hope that that bill would come forward. You might remember the genesis of it was, the background to it at the time was the disgraceful treatment by the Ryanair company of many of its workers at that particular time in the late 90s, the mid-late 90s. So I do have some concerns about the Workplace Relations Bill, particularly that this huge amalgamation may be driven more by cost saving than improving the situation for workers hoping to have employment or industrial relations issues resolved. I'm concerned, for example, also about the loss of the tripartite structure for cases currently falling within the remit of the EAT, and how this may affect the resolution of these disputes. Similarly, I'm concerned, Minister, about the qualification requirements for adjudication officers and the potential loss of expertise, and not ensuring a significant number of these officers come from the legal profession. In the area of enforcement, I very much welcome the strengthened provisions for upholding decisions of adjudication officers of the newly formed Workplace Relations Commission and the enforcement of compliance notices and fixed charge notices. However, I'm concerned that the move to have the majority of decisions enforced through the District Court, which is already a very busy system dealing with numerous different issues in areas of law, we've had a lot of difficulty, for example, with the implementation of traffic safety laws in the Districts Court, Minister, backlog of work. And therefore, I think there would be a grave concern that this could happen also to appeals under this bill before us. I know you said you're bringing forward some amendments at committee stage. I often wonder why a bill that's been in gestation for 2.5 years, why a department would have to bring forward amendments at a committee stage. I know you had a widespread consultation, but you'd imagine you'd come into the House with the bill ready to go to the statute book. On a similar note, while I welcome the Minister's decision not to impose fees for accessing the WRC, I note, however, that under Section 69 it does allow you to set some fees in relation, I think, to a second stage, if you like, of the appeal procedure. And separately, of course, there'll be a cost involved in recourse to the District Court system for the enforcement of awards, and I fear that this could dissuade some parties, particularly workers, from going down that route. I note that SIPTU, for example, has suggested that the Labour Labour Court should be further expanded to extend its scope to the enforcement of awards, and therefore having no cost to workers. And I'd agree with this view very strongly, and I believe the Labour Court would be better placed in terms of its expertise to enforce awards of the WRC. Overall, the decision to have a new WRC as the body of first instance for employment-related complaints and disputes, as well as having inspection and enforcement powers, it is a good step forward with the development of the so-called one-stop shop system, and equally the amalgamation of the appellate features of the AT and the Labour Court into the new expanded Labour Court is welcome. So the basic move, I think, in part 2 of the bill is to be welcomed. I note also the functions of the new WRC as outlined in section 10. I welcome the establishment of the Office of Director General under section 11 to 18. And also, turning to further provisions of the bill, I welcome the provision for the appointment of a registrar, who I understand will be the legal advisor to the WRC and the Director General. I question, however, the decision to have the board of the WRC, the structure of which is outlined in Schedule 3, as a non-executive board reporting directly to you, Minister, and to the Department. This could undermine, I think, the board's independence, and could be particularly difficult, for example, when the industrial relations arm of the new WRC are dealing with disputes concerning public bodies or publicly funded employers. The bill provides, of course, for the standardisation of time limits for the institution of proceedings under Part 4 of the bill, which deals with complaints and disputes. I note that Section 41 provides for a time limit of 6 months for referring a complaint or dispute to an adjudication officer. It is an important feature which should promote certainty for parties engaging with the new system. It will also be easier to understand than the current system, which has multiple fora and different time limits for taking actions under various pieces of employment legislation. I note also, Minister, and I welcome that there is scope for the time limit to be extended to 1 year in certain circumstances where the failure to present the complaint or refer the dispute was due to, and I quote, reasonable cause under section 41(7). I also welcome the standard time limits in place for compliance notices under section 27 and the fixed payment notice under section 35 of 42 days under which an appeal can be lodged against an compliance notice, and 42 days within which the amount indicated under a fixed payment notice must be paid. But a key area in which I have an interest, as I mentioned at the start, Cathaoirleach, is the enforcement provisions contained in Part 3 of the Act. I was previously very involved in campaigning for the establishment of NERA. I certainly wouldn't agree with IBEC's view that the inspectoral function currently exercised by NERA should not be included in the new WRC, as there will be important pooling of resources and information between all aspects of the newly created umbrella body of the WRC. Another key issue of concern, of course, is the number of inspectors, as I just mentioned, and cuts to their number, which may come to attention, which have come to my attention on numerous occasions. I understand the Minister, you did indicate to me that there's about 100 people in this function. Actually, it was last January. From my experience, however, there's a strong need to increase that number. However, one of your stated aims in your introductory speech was to save on staffing costs. A potentially significant provision of Part 3 is Section 32, which provides for disclosure of certain information in relation to public construction and other public contracts. I note the explanatory memorandum of the bill states that, and I quote, that this section is designed to safeguard the wages and other statutory entitlement of employees who are working under public construction or other public contracts, while also ensuring competitive tendering and value for money in public expenditure. I note a number of deputies earlier today, including Deputy Boyd Barrett, already referred to the greyhound workers' plight. I was also very concerned about that and remain concerned about that whole issue whereby workers were forced into accepting pay cuts, savage pay cuts, by a company which had its headquarters outside this country for a key public service function. And you remember when we were both in Dublin City Council, Minister, I led a campaign to keep waste management within the remit of the public sector, because I always thought we would end up with this type of situation which has now developed in the Dublin region and in which Greyhound has played a disgraceful role. There seemed to be no identifiable reason, for example, for the savage cuts to workers' pay in that company, other than increasing this company's profits and the profiteering of the leadership of that company. Of course, the fact that the dispute occurred in a firm providing a public service, as I've said, that more properly should have remained a state service, is another disappointing feature of this, and previous government lack of commitment to public service. So I think the Greyhound issue does does illustrate, as Deputy Boyd Barrett and others have said, grave deficiencies in protecting workers' rights in this country. Separately, as the Minister is aware, I've been raising on many occasions, including publicly in this House, just before the recess, or the summer recess, raising the issue of serious potential breaches of workers' rights on some sites operating under the school building programme. Of course, the matter is evolving as we speak, and the situation has escalated. Cathaoirleach, in particular, on the site, I think you Cathaoirleach, also raised this matter one morning at Leaders' Questions, on the site at Kisho Community College in Lucan in recent days. Key concern here, as you know, Minister, on this site and other sites, is the use of the subcontracting system to erode workers' rights and effectively reduce the price paid for construction services. And we heard from media reports, in fact, that some workers are effectively being paid half the minimum wage for doing, a highly skilled job like block laying or bricklaying or whatever. I referred the matter, of course, on a number of occasions to your colleague, Deputy Nash, Minister Nash, whom I hope will come back with a substantive plan to address this problem. I've also raised the matter. In fact, the matter was raised, I think, continuously with Minister Quinn, with former Minister Quinn, for over 2 years, and also Minister O'Sullivan, because obviously the sites in question are construction projects under the school building programme. I obtained figures from the Minister of Finance, Minister Noonan, which show that around 40,000 to 45,000 workers are registered under the relevant contract system in each of the past 3 years. Of course, it's hard to understand, Minister, why that system has been tolerated, if you like, by the Revenue Commissioners, given the fact that it seemed to be open to grave abuse. And I think a number of trade unionists have campaigned, representing building workers, have campaigned very strongly to address this, because effectively the nub of this, Minister, as you know, is that people who want to be PAYE workers, want to be absolutely fully compliant, are forced against their will in a sham situation, in a sham arrangement, to behave as if they are self-employed people. The vast majority of the RCT workers, of course, are registered as being within the construction sector, even though the RCT system doesn't apply to the meat processing and forestry sectors. For example, Minister Noonan informed me that in 2012, 42,420 of the 44,178 RCT workers were registered under the construction sector category. Similarly, in 2013, 44,674 of the 46,431 RCT workers were registered in construction. I also note, Minister, that a private company, Contractors Administration Services, CAS, has been engaged to inspect the sites in question. Workers have rightly complained that public bodies would be better suited to this task. I think this was a company specialising in auditing function, in an accounting function in terms of building sites. Perhaps this is a function that would be well suited with requisite skilled staff to NERA. That it's NERA that could carry out this type of function best. Perhaps this new Section 32, therefore, in your bill, will have implications for the ongoing situation at these public construction sites. It's vitally important, of course, that any potential illegalities or breaches of employment law are addressed. However, the separate issue of the contractors in these sites relying on legal provisions of the RTCT system to effectively opt out of having proper paying conditions for construction workers has to be tackled by this government. I mean, it is a total disgrace that the very much diminished public capital programme, and I hope next Wednesday, Minister, will be presented in this House with an expanded public capital programme. We've slashed it since 2008, but it's very remiss, I think, of the government that having set out, and I would commend Minister Quinn for his role in that, having set out a programme of school building, that we allow shenanigans to go on sites, one of which, a major contractor of which it is alleged is JJ Rattigan. I do understand and appreciate the rationale for the RCT system. However, the recent experience of workers on on these sites under the publicly funded school building programme highlights the difficulties within the RCT system and indicates that cost saving has meant that workers are effectively forced to become self-employed and lose most of the protections and entitlement available to employees under employment law. So the bill we're discussing today, I mean, cannot protect these workers. Equally, by virtue of being self-employed, they won't have recourse, of course, to any of the machinery, revised and streamlined machinery we're talking about today. So I'd urge Minister to work with your colleague, Minister Jed Nash and Minister O'Sullivan in Education to urgently resolve this issue in the interest of workers' rights and ensuring the proper use of public funding, and also obviously to work closely with revenue to see that a system that's fair to those workers will evolve while expediting the public capital programme. I'm supportive of the bill's provisions on mediation under section 39 to deal with disputes where this is agreeable to the parties concerned. I know there's a move more generally in the context of all legal disputes now to have recourse to mediation in the first instance, and the Minister will know our own law centre in Northside is now the Law and Mediation Centre. I think that symbolises the move towards mediation in legal matters, a very welcome move. It's important to have this reflected, of course, in the Workplace Relations Bill. Importantly, however, mediation is not being included to substitute the right of either party to have the complaint or dispute resolved in another manner under the legislation, as is provided for in section 39(1)(b). In summation, Cathaoirleach, then, I do welcome the general thrust of the provision of the bill. I hope the concerns that myself and other deputies have raised might be examined in the context of the committee stage. I mean, I was saying to you that you should come in with a finished bill, obviously, but I do expect you to listen to the committee as well. But what's unusual about this is that you tell us that you're going to do various amendments, that you could have done those before you came in, and then other amendments we might suggest and colleagues might suggest on the Jobs Committee could be added later. So, as I said, I do know you have committed to introduce those amendments. So I hope, Minister, it is a historic day in terms of the industrial relation machinery of the state. I wish you well in the manner in which the whole machinery is being modernised. But I would hope, in particular, that it's not just the cost grounds that will influence this, and that the adequate resources will be made available, and especially to NERA, to ensure that our 2 million, approaching again, fortunately, our 2 million workforce, and particularly those very low-paid workers in very vulnerable situations that the colleagues, Deputy Daly and Deputy Mick Wallace referred to, that those workers will be monitored carefully and protected. Cathaoirleach, thanks.